Assalamu alaikum. In our previous lecture, we were discussing the Electronic Transactions Ordinance 2002, which is the law in Pakistan that deals with electronic documents and electronic signatures. Let's just very briefly revise some of the provisions of the ETO that we covered last time. If you recall, I told you that in ETO there is a provision that wherever law requires a document to be retained and such document is retained in electronic form, then the requirement of law as a retention of the document would be deemed satisfied if, number one, that document in electronic form is accessible for any subsequent reference. Number two, this document is in its original form, or it is a copy of the original, or it contains the contents of the original form, and that thing can be verified to a satisfactory level. And number three, there is some document which indicates the time and the date of the issuance or generation of such a document. So if these three conditions are satisfied, then in case a document is retained in electronic form, still the requirement of law for the retention of a document would be deemed satisfied. Okay, then there is a provision in the ETO which says that who would be deemed to have sent an electronic communication. So there are three instances mentioned. A communication would be deemed to have been sent by a person if that person himself sends this communication, or there is a representative, an agent of that person who on his behalf sends the communication. Still that communication would belong to that person who has appointed an attorney or representative. Then it is possible that a person has established or arranged an automated information system which automatically generates messages. If that is the case, then again that would be the information sent by the person himself. That would be deemed that this information has been sent by the person who has arranged or established that automated information system. On the other hand, the addressee would be entitled to take this communication as authentic, and he can act upon that communication provided he has no occasion of any suspicion or doubt in this behalf about the authenticity of the communication. There is a provision in the ETO which makes the communication conditional, right? So there is a section which says that wherever the two parties, the originator and the addressee, they agree upon this thing, that the communication would only be deemed to have been made in case the addressee sends an acknowledgement of its receipt. If there is such an agreement, then the communication would only take place if the addressee sends the acknowledgement. If the addressee does not send the acknowledgement of the receipt of the communication, then it would be deemed that there has been no communication by the sender, by the originator. Right? The two parties, they can also agree upon a mode of acknowledgement. Like they can agree that the acknowledgement of the receipt of communication would only be made through email. If that is the case, then the addressee must send the acknowledgement of the receipt of the communication in the form of an email. If he does not do so, then there would be no valid acknowledgement, and that would not be acceptable. Where the mode has not been agreed upon, any specific mode has not been contemplated or agreed, then any appropriate mode through which the acknowledgement of the receipt of a communication is sent by the addressee, that would be okay, that would be valid. Similarly, where the conduct of the addressee is such that it indicates that he has got the receipt of this electronic communication, then again that would be a valid acknowledgement. So where the addressee conducts himself in such a way that he, for that matter, meets a person, Mr. A, whom he was required to meet as per the communication made to the addressee, then his conduct in fact is showing that he has got the communication. So there no specific acknowledgement would be required to be made on part of the addressee. His conduct itself is indicating that he has got the communication. So what's the provision in this regard? Let's have a look at it. There is section 14 of the ETO which speaks about this concept. Clause 1, unless otherwise agreed, where the originator has stated that the electronic communication is conditional on receipt of acknowledgement, the electronic communication is treated as though it has never been sent until the acknowledgement is received. Number 2, where the originator has not agreed with the addressee that the acknowledgement be given in a particular form or by a particular method, an acknowledgement may be given by A, any communication, automated or otherwise, by the addressee, or B, any conduct of the addressee sufficient to indicate to the originator that the electronic communication is received. There is another provision in the ETO which talks about the time and the place of dispatch and receipt of an electronic communication. So these two things, they are fundamental, they are quite important for certain legal purposes, that is the time of the dispatch and receipt of communication and the place of its dispatch and receipt. The main principle that you need to understand is that the ETO says that dispatch of an electronic communication would be deemed to have been made on part of the sender, on part of the originator, at the time when that electronic communication enters an information system which is beyond the control of the sender or the originator. For that matter, I can give you an example. Say a sender and originator sends an email message. Once that email message enters an email server and is stored there, which email server is beyond the control of the originator or the sender, it would be considered, it would be supposed that the dispatch of this email message has been complete on part of the sender or the originator. The moment it enters that email server, the communication is complete on part of the sender or the originator. Then the time of the receipt of this electronic communication as regards the addressee, the recipient of this communication, would be when this electronic communication enters an information system which is the designated or predefined, pre-agreed information system of the addressee, or it enters an information system which is, although not the information system of the addressee, but when the addressee accesses that information system and retrieves this information from there, that would be the time of the retrieval of that information from that information system would be the time when it would be considered that he has received this information. Or thirdly, as regards the communication, the receipt of communication to the addressee, when the information, the communication enters the information system of the addressee, it may not be his designated information system, it may not be any email server which he has designated, but it is his information system, his own information system. So when the information enters into that information system, that would be the time where it would be said that he has received this communication. Again, let me tell you that the timing of the dispatch and receipt of information or communication is important to be figured out, because the time limit for the filing of a legal claim in a court of law has to be determined on this basis. There is a specific law, the law of limitation, which specifically deals with this concept that a litigant, a person who has a legal claim against some other party, he has to come to the court of law agitating his claim within a particular prescribed time period. So for the calculation of this time period in which a party has to come to the court bringing his claim before the court, the calculation of that time in this particular scenario will have to be calculated on the basis of the receipt of the communication or the dispatch of the communication, as the case may be, right? Just to give you an example, in the traditional sense, in our traditional laws, if I want to file a case against a person for the breach of a contract, that person violated the contract he entered into with me previously, then one remedy for me is to file a suit for damages against that person for the breach of his contract. So there is a law of limitation in our country which says that I should file that case within the period of 3 years from the breach of the contract. From the date when the breach was committed, I should go to the court within the period of 3 years. If I go beyond this prescribed period of 3 years, then my case is called, it is said to be barred by time. It would not be entertained by the court. So I hope that you understand this point, that the law of limitation, it has its significance, and for that purpose we need to be aware of the timing of the dispatch and receipt of an electronic communication wherever the disputes in relation thereto arise. Then the place of electronic communication, of its dispatch and its receipt, that again is quite important, because on that basis the territorial jurisdiction of a court would be determined. Remember I told you about the territorial jurisdiction, right? So this is the competence, the power of the court to entertain and decide a case legally on the basis of territory or area. So if a dispute arises in Lahore and it has no connection at all with Karachi, then I can only file my case at Lahore, in the court at Lahore. I cannot take my case to Karachi, in a court at Karachi, or say in Faisalabad, etc. Because the territorial jurisdiction to decide this case would be vested with the court at Lahore. So ETO says that the place of dispatch and receipt of communication would be deemed to be that where the originator or the addressee either resides or he or she has his place of business. It is a deeming clause which means that it would be supposed that the dispatch or the receipt of the communication has taken place at a place where either there is the residence of the originator or the addressee, or there is his or her place of business. So what is the specific provision in this regard? I can show you a slide. Let's go to the screen. This is section 15 of the ETO, clause 1. Unless otherwise agreed between the originator and the addressee, the dispatch of an electronic communication occurs when it enters an information system outside the control of the originator. I've already explained that, so no need to reiterate this concept again. Then clause 2, unless otherwise agreed between the originator and the addressee, or unless proved otherwise, the time of receipt of an electronic communication is determined as follows. Now you can notice that the words unless otherwise agreed indicate that the parties, the originator and the addressee, they are at a liberty to decide anything different. If they do not decide anything, if they do not agree anything different, then the following clause that would take its effect. And this goes as follows. Subclause A, if the addressee has designated an information system for the purpose of receiving the electronic communication, receipt occurs, number 1, at the time when the electronic communication enters the designated information system. So if the designated information system is the Hotmail email server, then the moment the email message gets stored or enters into the Hotmail email server, it would be deemed that the receipt of that communication is effectuated. Number 2, if the electronic communication is sent to an information system of the addressee that is not the designated information system at the time when the electronic communication is retrieved by the addressee. Now the key word is retrieved. It is not a designated information system, but it's some information system, and the moment the addressee retrieves that information from there, it would be said that this is the time he has received this information. The time calculation for limitation period would be calculated therefrom. Then subclause B, if the addressee has not designated an information system, receipt occurs when the electronic communication enters an information system of the addressee. That is his own information system. When the information enters there, that would be the time of its receipt. Then this section further goes on in its clause 3. It is stated, subsection 2 applies notwithstanding that the place where the information system is located may be different from the place where the electronic communication is deemed to be received under subsection 4. And what is subsection 4? Unless otherwise agreed between the originator and the addressee, an electronic communication is deemed to be dispatched at the place where originator ordinarily resides or has his place of business. There are two possibilities: either he ordinarily resides or has his place of business, and is deemed to be received at the place where the addressee ordinarily resides or has his place of business. So this specific subsection 4, it deals with the place of dispatch and receipt of an electronic communication. Now let's go back to subsection 3, which in fact says that the time for the dispatch or receipt of the electronic communication as described in subsection 2 would apply to subsection 4. So wherever the place of dispatch or receipt of a communication is, irrespective of that, the criteria for the calculation of time as indicated in subsection 2, that would be applicable. Then subsection 5. For the purpose of this section, A, if the originator or the addressee has more than one place of business, the place of business is that which has the closest relationship to the underlying transaction, or where there is no underlying transaction, the principal place of business. It means that where the originator or the addressee have more than one places of business, then either the place of business which is closely linked to the transaction or which is the principal, the main place of business, that would be considered as the place of dispatch or receipt. Then the clause B, if the originator or the addressee does not have a place of business, reference is to be made to the usual place of residence. And C, usual place of residence in relation to a body corporate. Body corporate means, say, a company which has a separate legal entity or which is a separate legal person, means the place where it is incorporated or otherwise legally constituted. There is a section in ETO, section 16, which says that nobody will have any right to insist that an appropriate authority must issue a document in electronic form, or it must accept a document in electronic form or retain such a document. However, this section further says that wherever an appropriate authority is issuing documents, accepting documents, retaining documents, or an appropriate authority is issuing licenses, certificates, etc., or where an appropriate authority is making payments or entering into transactions under a law or under a predefined procedure, then it would be an option available with the appropriate authority that it may decide on its own to issue, accept, file, retain any such documents in electronic form. It can also issue certificates, licenses, etc. in electronic form. It can make payments in electronic form. It can complete transactions in electronic form, but that would be an option available to the appropriate authority. Nobody will have a right insisting upon the appropriate authority to do so. And that would only be possible where the appropriate authority is already obligated under some law to take these actions, to maintain documents, to issue certificates, to complete transactions, to make payments, etc. Further, the section 16 says that the manner, the format of issuing such documents, that would also be decided by the appropriate authority. It can also define the requirements, it can set out the procedure, it can say that, well, this would be the type of electronic signature that would be required to be applied on the electronic document, etc. All these different things, they can be specified by the appropriate authority itself. Then there is a provision in the ETO which says that any certification service provider which is not accredited by the Certification Council, such certification service provider would be entitled to operate in Pakistan. There is no prohibition in this regard. So this is not mandatory that you must be accredited by the Certification Council in order to provide the services as a certification service provider. You may be non-accredited, you can still operate in Pakistan. But there is a clause which says that any such service provider which is not accredited, it would not represent or it would not hold out to be an accredited certification service provider where it has not got the accreditation certificate by the Certification Council. So let's see what is the provision in this behalf. I'll take you through section 16. Again, I repeat, I don't intend you to memorize this section word by word. Just have a basic concept and then you can write in your own words the main concept, the gist of the section or the provision. Now section 16, clause 1, nothing contained herein before shall confer means provide, give, a right upon any person that any appropriate authority should accept, issue, create, retain, preserve any document in electronic form or effect monetary transaction in electronic form. Monetary means financial transaction. I've already told you what an appropriate authority means, so I don't need to repeat that here. Then clause 2 is any appropriate authority pursuant to any law or procedure A accepts the filing of documents or requires that documents be created or retained. B issues any permit, certificate, license or approval. Or C provides for the method and manner of payment, procurement or transaction, may notwithstanding anything contained to the contrary in such law or procedure. Now you should be clear what is the significance of the words notwithstanding anything contained to the contrary. It means that this provision, section 16, would have a dominating effect in case some other provision of law is in conflict with it. It will have dominance, it will have an overriding effect on that law. Then subclause 1, except the filing of such documents or creation or retention of such documents in the form of electronic documents. 2, issue such permits, certificate, license or approval in the form of electronic document. Or 3, make such payment, procurement or transaction in electronic form. I repeat, the idea behind this section is that wherever an appropriate authority under a law accepts the filing of documents, issues certificates, permits, makes payments, does procurement, completes transactions, etc., then that appropriate authority would have an option to do all these activities in electronic form. And if any law goes against that, that law would be overridden by this provision. This provision would have an overriding effect on that law. Then subsection 3, in any case where an appropriate authority decides to perform any of the functions in clause 1, 2 and 3 of subsection 2, may specify A, the manner and format in which such electronic documents shall be filed, created, retained or issued. B, when such electronic document has to be signed, the type of electronic signature, advanced electronic signature or a procedure required. All these things may be specified by the appropriate authority. C, the manner and format in which such signature shall be affixed to the electronic document and the identity of or criteria that shall be met by any certification service provider used by the person filing the document. D. Control process and procedures as appropriate to ensure adequate integrity, security, and confidentiality of electronic documents, procurement, transactions, or payments. And E. Any other required attributes for electronic documents or payments that are currently specified for corresponding paper documents. Section 17, Clause 1, it says, nothing in this ordinance shall impede or in any way restrict the rights of any certificate service provider to engage in the business of providing certification services without being accredited. Subsection 2 is, no person shall hold himself out, means represent, as an accredited certification service provider unless he holds a valid accreditation certificate issued under Section 24 by the Certification Council. And I've already explained the scope of this provision. You may have noticed one thing, that legal jargon is quite difficult. And making a law, drafting a law, I tell you, it's a huge effort. So you have to be very selective, you have to be very thoughtful about the choice of words that you are going to use to prepare a clause of law, because every word would have its own connotation, its peculiar significance. It may have different interpretation, right? So you may have realized that it's a tough job. And the lawyers, they don't have an easy job at hand. And the courts, again, they have to make an effort to interpret a law, the provision of law according to the intention of the lawmakers. So that is the main job that the lawyers, the court, they have to do while interpreting a law. Okay, then we have talked about Certification Council quite frequently. Certification Council is a body that has been created under the ETO. In fact, there is Section 18 of the ETO, pursuant whereof a Certification Council has been constituted. It has to be constituted by the federal government. Now, the role of the Certification Council is that it has to supervise the working, the operation of the certification service providers. It has different functions, but one major fundamental function of the Certification Council is that it has to provide the guidelines which are to be followed by the certification service providers. So you will see what are the various functions of the Certification Council in the subsequent slide. The Certification Council is a 5-member body. There are 5 members of the Certification Council, and each member will have to be appointed for a period of 3 years by the federal government. There would be a chairman who would preside over the meetings of the Certification Council. The decision of the council would be made by the majority vote, and where the vote is equally divided on 2 sides, then the vote of the chairman would be the decisive vote. It would be the casting vote. The members of the council would be picked up, the 4 members in fact would have to be picked up from the private sector by the federal government. Now, the qualifications of the members, they are listed in the ETO. So amongst the 5 members, one has to be a telecommunication engineer having an experience of at least a period of 7 years in the field of cryptography. Then there must be 2 individuals as members who are to be picked up from the field of information technology. They may be professionals working in the field of information technology for a period of 7 years, or they can be persons who are engaged in the academics in the field of information technology, and they have an experience of at least 7 years in this regard. Then one person would be selected from the administrative side. So an individual having an experience of at least 7 years in the private or the public sector on the administrative side can be a member of the certification council. And the fifth member has to be a lawyer who has at least 7 years of experience in the field of information technology law. So in this fashion, the certification council would be constituted, and it will have its specific function. The funds of the council, how the council would finance itself: first of all, there would be funding, there would be grant by the federal government. Then some revenue can be generated by the council by the issuance of the accreditation certificates to the certification service providers. Accreditation certificate means licenses to the certification authorities, certification service providers, and there would be some fee which the certification service providers will have to pay. And then there can be different types of fines which the council can impose, and through that it can generate its revenue. There can be a fee which can be collected from the persons who are issued the digital certificate. So in this way, the funds are generated by the council. So let's see what are the provisions in this regard. Section 18 talks about the creation of the certification council. Clause 1 says, within 60 days of the promulgation, means introduction of this ordinance, the federal government shall, by notification in the official gazette — official gazette is a book where the notifications, the laws, they are published officially — constitute a certification council to be known as Electronic Certification Accreditation Council. Then subsection 2, the certification council shall be a body corporate. Body corporate means it will be a separate, a distinct legal person with perpetual succession and a common seal, and shall by the said name sue or be sued. It would be a legal person in itself, and in its own name it can sue or it can be sued. Then subsection 3, the certification council shall comprise of 5 members, with 4 members from the private sector. One of the members shall be designated as the chairman. And there are, in fact, other subsections from subsection 4 to 9, and I am skipping that because I have already discussed these features with you. No need to repeat them again. Although I would show you a slide which sets out the details in section 19. Section 19 is, of the 5 members of the certification council, A, one shall be telecommunications engineer with at least 7 years work experience, of which at least 1 year is in the field of cryptography services. B, 2 shall be professional or academics with at least 7 years work experience in the field of information technology. C, 1 shall have an administrative background with at least 7 years experience in a private or public organization. And D, 1 member shall be an advocate with at least 7 years experience and adequate knowledge of laws relating to information technology and telecommunications. Section 20, the funds of the certification council shall comprise of A, grants from the federal government; B, fee for grant and renewal of accreditation certificate; and C, fee not exceeding 10 rupees for every certificate deposited in the repository; and D, fines. What are the different functions that the Certification Council will be required to perform? The answer is contained in section 21. So section 21 sets out the powers, the authority which the council would exercise. Mainly, I tell you, number one, the main function of the Certification Council would be to issue the accreditation certificates to the appropriate certification service providers. Accreditation certificates are sort of licenses which permit the specific certification authorities to operate as an accredited certification authorities in Pakistan. The council would also be authorized to cancel or revoke any such accredited certificate to a certification authority if the certification authority is not performing its functions according to law. Then its accreditation certificate can be revoked or cancelled by the council. The Certification Council would also ensure that the accredited certification service providers, they comply with the provisions of this ordinance. So they perform their functions according to different provisions of this law. It would pose a check on all such certification service providers. Then another job that the council will be required to do is to establish and maintain a repository or a data bank. It would be a data bank, say a database, where the accredited certificates would be placed along with the digital certificates issued by the certification authorities to the clients. So both these types of certificates, the accredited certificates issued to certification authorities and the digital certificates issued by the certification authorities to the clients or the customers, both these types of certificates would be housed, would be placed in the repositories which would be established by the Certification Council. Such a repository would not be a restricted place. It can be accessed by any individual, and people can access the repository and they can view the information placed there. In case the Certification Council cancels or revokes or suspends the accreditation certificate in favor of the certification service provider, the information in this behalf would also be placed in the repository so that the public can get to know about this event. Then the job for the Certification Council would also include that it can provide advice to individuals, to persons, to appropriate authority, to government, as regards the interpretation or the terms contained in this ordinance. So if there is any ambiguity, any problem, any issue which is not being understood, any person can contact the Certification Council for advice. There is a specific authority given to the council in this regard. Let's look at the screen. Section 21, subsection 1. The Certification Council shall perform such functions as are specified in this ordinance or may be prescribed without prejudice to the generality of the foregoing subsection. The Certification Council shall, and there are certain powers listed. Now these words, without prejudice to the generality of the foregoing subsection, again it's a peculiar legal language. This phrase means that the general criteria or the general authority given to the Certification Council in the subsection 1, that would not be affected, but there are certain specific authorities or powers we are hereby giving to the Certification Council. And what are these powers? A. Certification Council can grant and renew accreditation certificates to certification service providers, their cryptography services, and security procedures. B. Monitor and ensure compliance by accredited certification service providers with the terms of their accreditation and revoke or suspend accreditation in the manner and on the grounds as may be specified in regulations. There are certain regulations which are to be framed by the Certification Council under Section 43 of the Ordinance. We shall discuss that later. C. Monitor compliance of accredited certification service providers with the provisions of this ordinance. D. Establish and manage the repository. E. Carry out research and studies in relation to cryptography services and to obtain public opinion in connection therewith. F. Recognize or accredit foreign certification service providers. G. Encourage uniformity of standards and practices. H. Give advice to any person in relation to any matter covered under this ordinance. I. Make recommendations to an appropriate authority in relation to the matters covered under this ordinance. In Section 23, subsection 1, the Certification Council shall establish and manage a repository for all accreditation certificates issued by accredited certification service providers and for such other information as may be specified in regulations made by the Certification Council. Subsection 2, the Certification Council shall take appropriate measures to ensure the security of all information contained in the repository. 3. All information contained in the repository shall be open to public inspection. 4. Notice of suspension or revocation of any accreditation or of certificate issued by an accredited certification service provider shall be posted in the repository within the prescribed time. So that was the main discussion as regards the Certification Council, how it is constituted and what are the various functions it has to perform under the ETO. All this discussion is contained in Chapter 5 of the Electronic Transactions Ordinance. Let's have a look at what we have done in our today's lecture. We have basically discussed as to what is the significance of time and place in relation to the dispatch and receipt of electronic communication. I told you that the limitation period during which the case has to be filed in the court in relation to any electronic document related dispute, that has to be calculated on the basis of that time. Then territorial jurisdiction has to be determined on the basis of the place where an electronic communication is dispatched or where an electronic communication is received, etc. We have also discussed that at times it can be agreed that an acknowledgement of the receipt of an electronic communication would be a mandatory thing. So unless that receipt of acknowledgement is not there, the electronic communication may not take place at all. Then we have also seen that there is a provision in the ETO which says that an appropriate authority would not be obligated to issue, to accept, to retain documents in electronic form. No person can have a right insisting upon the appropriate authority to accept a document in electronic form, but there are certain instances where an appropriate authority may on its own decide that it would accept, it would issue, it would retain, etc. documents in electronic form. And we have seen there is a specific provision in this regard. We have also examined the scope of the certification council, how the certification council is constituted, what are the qualifications for the members of the council, what are the various functions it has to perform under the ETO. In a subsequent lecture, we'll specifically talk about what are the various offenses which are set out in the ETO. So for the time being, let's conclude our lecture. Allah Hafiz.